Hello, everyone. Good afternoon. Welcome back, for those of you who are back, to our webinar series. Today, we are doing the webinar together with Clyde and Co. We are doing it with Yvonne, who you already know, and Mikaela. I'll let them introduce themselves in a minute. So the reason we are here today and the reason we're talking about advertising is because ASIC has recently released an updated guidance, RG 234, on how to comply with already existing regulatory obligations when it comes to advertising your products and your financial services. So we're going to walk through this today, and thank God we've got an amazing law firm and two amazing lawyers to stop me from jumping straight into RG and reminding me, no, we always have to come back to the law on these things. We can't just assume things that we already know them and just use the ASIC guidance. So I have a good agenda for you today. Let me just start before we jump into the agenda. As we're talking about advertising, let me just open up the floor to a very quick 2-question poll. Just tell us if you already run some form of process, some form of compliance sign-off or something like that process before you release your marketing communications. Just launched a poll. Just let me know if it's as it comes through. Yeah, can you see it? Yeah, please. So let me know what it is. We'll start with a little question just to understand where on the probability curve you are. Okay, so a lot of people say yes, and funnily enough, a lot of people say no idea, maybe. All right, so 82% are saying yes, we do have some form of process, and 17% saying no, and only 2% are saying no idea. So it's not tracked. Your name is not tracked against it. So I don't know who said what. All right. Thank you. And for those who clicked yes, majority, there's still responses coming. Okay, I'll give you 2 more minutes. For those who clicked yes, I would actually want to know how effective that process is. Because today, what we're going to be talking about effectively is what to do about it and what you need to know. All right, let me launch another one. So for those who said yes, who do have some form of sign-off process, let us know how happy or unhappy you are with it and if it's effective. If it's like easy, same day of approval, or if it's like, okay, it's maybe it takes you 1 or 2 days to actually get things approved, or if it's not effective and it like, seriously causes a lot of delays for you. Okay, to be honest, I'm surprised. A lot of people say not effective. All right, only the minority are saying it's effective. That's a pity. It might get more complicated for you going forward, unfortunately. All right, okay, I think we've got a consensus more or less. Very few people, 15% are saying it's effective. Almost half is saying it's okay, it's 1-2 days delay. And almost 40 or 37% are saying actually it's not okay, it's not effective and it keeps delaying the marketing. All right, thanks for that. That's just an opening, almost like an appetizer for what we're going to be discussing today. So I'll open the floors. As I said, we're going to be speaking about the ASIC guide on advertising. But before that, we'll go back to the law, to the actual letter of the law, and speak about what constitutes misleading and deceptive conduct. How does it look like and where to find the basis for it? Then we're going to go into the guide and actually look at it and say how it compares to the previous ones and what are the extra obligations or clarifications that ASIC has issued. Then we're going to go into examples of what good versus bad looks like when it comes to advertising and finish up with some practical tips. Before I jump into it, please, Yvonne and Mikaela, introduce yourselves and then we'll get going.
Thanks, Tetiana, and good afternoon, everyone. My name is Yvonne and I'm a partner with international law firm Clyde Co, and I specialise in advising the insurance sector on corporate insurance and regulatory matters, and I work with clients like Curium to navigate the complexities of the Australian regulatory landscape. Really pleased to have the opportunity to take you all through the webinar today with Tetiana and also Mikaela, who I'll just pass on to now to introduce herself.
Hi everyone, I'm Mikaela Eldridge. I'm a senior associate at Clyde Co, working with Yvonne Lamb. I work in the global regulatory and investigations team with a focus on corporate regulatory matters. Prior to joining Clyde's, I worked in enforcement at ASIC, so I kind of bring a different perspective to Yvonne of what the regulator is looking at.
Perfect. All right, please post your questions in the chat. We'll try to leave some time at the end, but let's get going. All right.
Thanks, Tetiana. So we'll start off today with a recap on the prohibition against misleading and deceptive conduct as it stands currently under Australian law. So if we move on to the next slide, this is a phrase that many of you in the audience will have heard being used in a legal context over the years. It is a pretty key prohibition that exists in a number of different pieces of Australian legislation. And it's really a prohibition that's designed to protect consumers and investors from making decisions that are based on false, inaccurate, or incomplete information. And in a nutshell, a company or person must not, in relation to financial products or financial service, engage in any conduct that is misleading or deceptive, or that is likely to mislead or deceive. So this includes where you make any false or misleading statements, or also where you might be making claims or representations that are likely to create a false impression in consumers as to things such as the price, the value, or the quality of goods or services on offer. So the law in this space hasn't really changed recently, but as Tetiana has already mentioned, and as Mikaela will take you through in the second section of this webinar, the regulators' expectations about how regulated financial services entities in Australia approach this to ensure that they don't fall foul of that prohibition has been restated in the new ASIC regulatory guidance. So before we get into that, we just wanted to take you through some key principles in this space. It's a very broad concept and it is very dependent on the different facts and circumstances that could contribute to the conduct. There's been a really extensive body of Australian case law that's been developed over the years, with this legal concept being tested before the courts in a variety of contexts over decades. So what comes out of all that case law is the central question where you look at conduct of whether it is misleading or deceptive. The courts will look at whether the particular conduct, when it's viewed as a whole, has a sufficient tendency to lead a person who's exposed to that conduct into error. So that's whether the court's looking to see if that person has formed an erroneous assumption or an erroneous conclusion about a fact or matter that's at play. So the case law's developed some key concepts and principles that can help guide entities when they're trying to determine if they might be falling into territory that could be considered to be misleading or deceptive conduct, or to identify where there might be instances of potential misleading or deceptive conduct in their business operations already. So we've got these up on the slide and I'll just take you through them very briefly. So conduct will be considered to be misleading or deceptive if it has that tendency to lead a person into error. So what we're looking for here is that there is a causal connection between the conduct and the potential error that could form as a result of that conduct. It has to be a conduct that has a likelihood that is real and not remote in terms of the chances of it creating that misleading or deceptive impression. And it's not sufficient if the conduct just merely causes confusion in a person. So while deception can commonly feed off error or confusion, conduct that just confuses a person doesn't necessarily result in misleading or deceptive conduct. There needs to be a bit more at play there. So you might have misleading statements that are express, but equally you can also have misleading statements that can be implied from the other words or conduct when you look at it as a whole. And importantly, misleading or deceptive conduct can result where there's an omission or non-disclosure. So sometimes, particularly in a financial services context, if you withhold any key information about, for example, things like risks in relation to a product, if you're in an advertising context, that itself could possibly constitute misleading or deceptive conduct. The other thing to keep in mind is that silence itself can also be misleading or deceptive, where it's a circumstance that it's reasonable for a customer or a consumer to expect any disclosure of important information. So where you're silent on any important details, that can cause a statement to become misleading, even though it's factually correct. It also doesn't matter if there was any intention to mislead or deceive. What really matters is how those statements and conduct might affect the thought process or the beliefs of a consumer who's receiving that information. And the law still applies, even if there is no suffering of any loss or damage as a result of that conduct. And it's also not necessary to show that anyone's actually been misled or deceived by the relevant conduct. The prohibition's really against any likelihood of that misleading or deception happening. And what the court really comes back to is an objective test of whether, in the context, evaluating that particular conduct, is it likely to mislead or deceive someone who's an ordinary and reasonable member of the audience who's receiving that information. And as we'll see, as we step through some of the examples today, that really does depend on the facts and circumstances. And what we see, particularly also in an advertising context, where we step through some of the ASIC guidance, if you are already creating a misleading impression in any advertising or any other communications, it can't be cured. So simply just putting something that links to an accurate document or an accurate disclosure statement can't undo the effect of a misleading piece of advertising. So we need to keep all of these concepts in mind as we step through, because there's a lot to it. So this is the law. But as we said earlier, the regulator does expect that the law is applied in business operations in a way that makes sense. And so there's really a strong focus on the impression that's created in the different communication channels that you use to communicate with your customers. So we'll just step through now to the next slide, please, which, as you'll see, we don't make it easy in terms of having the prohibition put in a number of different pieces of legislation. So for our purposes, it's spread across in a financial services context through the Corporations Act, as well as the ASIC Act, and also the Competition and Consumer Act, which can all contain variations of the prohibition. So I won't go through all of them in detail today, just to note that the Corporations Act prohibitions are more focused on financial products or financial services. So we've got the key one up there, section 1041H, which prohibits a person from engaging in conduct in relation to a financial product or a financial service that's misleading or deceptive or is likely to mislead or deceive. So that's the main one that is in our Corporations Act, and it's supported by a couple of other sections, such as section 1041E, which relates to false and misleading statements about financial products, and section 1041G, which relates to engaging in dishonest conduct in relation to financial products or services. There's also the ASIC Act provisions, which are more focused on the financial services aspect. So we've got section 12DA, which is a prohibition against a person in trade or commerce engaging in conduct that in relation to financial services that is misleading or deceptive or likely to mislead or deceive. There's that extra reference to trade or commerce compared to the Corporations Act prohibitions, and it's supported by section 12DB, which is a popular one with ASIC. It relates to false and misleading representations in the supply of financial services or the possible supply or promotion of financial services. There's also a reference specifically in that prohibition against the representations made to prices of services, the existence, exclusion, or effect of any condition, warranty, or guarantee, right or remedy in relation to such services. So the prohibition applies in those contexts. And there's also section 12DF that goes in further and talks about engaging in misleading conduct about the nature, characteristics, suitability, or quantity of financial services. And then lastly, the Competition and Consumer Act, which is the one that most of you would have heard of. It's in section 18 of the Australian Consumer Law, which is a schedule to that act. And it's the main prohibition prohibiting a person from engaging in trade in conduct that is misleading or deceptive or is likely to mislead or deceive in trade or commerce generally. So that's the overlay. That's a lot of different prohibitions.
Can I just jump in here? So the difference between the first two and the third, if I may, because we deal with this all the time when we compile the obligations registers. How are these two different? They kind of say the same thing. The difference would be the part of the business to which it applies. The first two will apply to your advertising of your financial services. For example, claims is a financial service, dealing in insurance, selling, and so on. Products, description of your products. The last one, the Competition and Consumer Act, will apply to everything else. So let's assume you do also something like recovery. You do claims recovery, right? It's not a financial service. But if you deceive in the advertising of that, this is where this act is gonna catch you. So the first
so it's a more general prohibition that's not specific, to financial services and products. That's right.
Exactly. So whilst it might not be caught by the first two, there's financial services one. If you're providing a non-financial service, like a lot of supply chain services, that's the last bit that's going to be caught by that one.
That's helpful. Thanks for pointing that out, Tetiana. I think, the main difference is that the first two are specific to financial services or products, and it turns on what part of the business that's being impacted, what the facts and circumstances are, and what's the communication channel that you're communicating with the audience through. And also there is a relationship, as it can refer certain misconduct to the ACCC. It just depends. So ACCC is the regulator that then would enforce the Australian Consumer Law Competition and Consumer Act provision. So it just depends which regulator might be engaged depending on what is at play. So we'll just move on now to a couple of examples. These are more focused on the ASIC angle, given the topic of today's webinar. So that it has been an area of regulatory enforcement focus for the past couple of years. And ASIC has doubled down on this year. They have signalled that it remains a 2026 enforcement priority, where they're really focused on misleading pricing practices that impact the cost of living for Australians. They've really followed through on this enforcement priority with several actions in the past year, particularly in the insurance industry. So both the general and the life sectors have a recent example. And the one we just have up on the slide right now is the general insurance sector example, where ASIC did commence proceedings in the federal court last September against RACQ, alleging contraventions of Section 12DB of the ASIC Act. So that's the false and misleading representations in connection with the supply of financial services. And what's alleged in this case is that between September 2019 through to December 2024, that RACQ sent more than 570,000 renewal documents to customers where they contain certain representations about the last period's premium amount, which ASIC alleges was false and misleading, where a lot of the times that last period premium amount was higher than what customers had actually paid or were paying after certain negotiated discounts or changes to their policies that then reduced their premium were made. So it was a distorted view in terms of how much the premium was actually being increased in this renewal. So the example that was given by ASIC was where there's an RACQ customer who received a notice that showed the last period premium was about $6,900 and the new premium was about just over $7,000. And that looked like a 1.5% increase based on those calculations. But in that particular case, the customer had actually paid a much lower $5,000 premium, which meant the reality was that the increase was about a 40% increase on renewal. So in those circumstances, ASIC alleged that RACQ knew that last period premium representation in those renewal documents was misleading customers because they actually started receiving complaints a couple of days after they started sending out that type of notice. And as a result of all that, ASIC did commence the proceedings to seek declarations, civil penalties, and that RACQ makes written adverse publicity orders about that misconduct. So this matter remains before the courts at the moment. So we'll wait to see and watch this space as it makes its way through the courts. Then we'll just move on to the next slide, please. Thank you. This one's the life insurance sector example. So June last year, ASIC has also commenced proceedings against insurance comparison provider Choosy. And here they've alleged contraventions of, again, Section 12DB of the ASIC Act, as well as Section 12DF, which is around misleading conduct about the nature, characteristics, suitability, or the quantity of financial services. And here, ASIC has alleged that Choosy made some false or misleading representations to customers by claiming that it compared insurance products from a range of different funeral and life insurers. But the claim from ASIC is that from 1 July 2019 and as it stands presently ongoing, it's only comparing policies that were issued by a single insurer with one limited exception. And all of those policies were distributed by Greenstone Financial Services, which is a company that's associated with Choosy. So in that context, the allegation is that there's been over 4,000 funeral insurance policies, over almost 9,500 life insurance policies that were sold during the period that this setup was in place, and Choosy received $61 million in commissions. So here the allegation is that Choosy's made those misleading representations on its website, across social media channels, and via television commercials and advertorials. So ASIC is seeking declarations again, pecuniary penalty orders, and that Choosy makes some written adverse publicity orders about that misconduct. And they're also seeking an injunction that prevents Choosy from continuing to make those representations. The trial did occur in May this year, and it's currently awaiting judgment. So it's another one that we'll need to watch this space to see what results from those judgments. So with that, I'll pass you over to Mikaela, who will take you through the guidance on ASIC's expectations as a regulator in this space.
Right, we might jump to the next slide if that's okay. So Reg Guide 234, the focus is on how you advertise financial products and services to avoid misleading and deceptive conduct. The guidance applies to any communication intended to advertise financial products or financial advice services, as well as credit products and credit services. It applies to people who promote the products and services, and promoters will sometimes be the product issuer, but can also be third parties such as financial advisors, distributors, intermediaries, underwriting agencies that promote the product to potential clients. It also applies to the publishers of these promotions. So think about that: television networks, newspapers, radio stations, social media, and other digital platforms, or such as Google search engines. So in June this year, ASIC updated Reg Guide 234 for the first time since 2012. So there was a lot to update because a lot has happened since. But you'll be really happy to know that the guide is not a wholesale rewrite of ASIC's advertising principles. As Yvonne says, the law hasn't changed, so that means the principles largely have not changed. What it has done is basically the changes in the guide reflect the modernisation of the law and also the situation that we're in. So it reflects modernising the increase in technology, emerging issues, updates to corporations legislation, and the enforcement activity that has occurred over the last 14 years. So this has resulted in new examples in the Reg Guide, and also the applying of ASIC's principles to new scenarios. It's also resulted in some new key principles on how you should approach advertising. And the most important one's there on the slide, which is kind of an overarching principle, which is ASIC considers that the most important consideration when you are looking at your advertisement, hopefully before publishing, is the overall impression created by the advertisement when it's viewed by a consumer for the first time. So that kind of puts the responsibility on you, and it says consumers aren't expected to review advertisements multiple times. It's got to be, is it misleading based on a first and only view? And that overarching principle becomes more important when we look at emerging technologies and way to advertise, such as on social media. And look, I would use that principle kind of as a test, as a last way when you have your compliance team, as we were talking about earlier, reviewing the advertisement to consider it from that angle, because no doubt that is exactly what ASIC is doing when they're looking at your advertisements before deciding whether they need to investigate this further. So let's go to the next slide, and we're going to focus on two really key areas when looking at the updates. So Reg Guide 234 is kind of broken down into two sections. Firstly, the content of the advertisement, and then how and where it's advertised. And ASIC says, and well, actually all case law says, is that it's not just an overall impression of an advertisement, and whether it's misleading isn't just related to the content, but it relates also to how and where it's advertised. So focusing first on the content, as I said, ASIC has not changed the principles. The same principles apply as the old Reg Guide, and a lot of the time, the key guidance is the same. All it's done is kind of built on that in relation to emerging issues and new law. So you'll see here the 10 key principles that,
Apologies.
and we'll pop back a slide if that's okay. Thanks. The 10 key principles that are there have not changed, and we can go through them really quickly, but hopefully you guys all know them. Advertising should give a balanced message about the return, features, and benefits, and benefits should not be given too much prominence in comparison to the risks. In this section, ASIC actually draws on the emerging issue of greenwashing. I'm sure everyone's heard about it, but in case it's not, greenwashing is a type of misleading and deceptive conduct, and involves misrepresenting the extent to which a financial product or service is environmentally friendly, sustainable, or ethical. And essentially, you just got to be careful in making sure the representations you make about ESG matters is completely accurate and you can substantiate it. So generally, I would avoid making unqualified or exaggerated claims around your products or business being green, carbon neutral, net zero, ethical, or sustainable, unless you can back it up. The second one, warnings, disclaimers, qualifications, and fine print. It's kind of in there. It needs to have equal prominence as any headline claims, and it can't be inconsistent with the other content of an advertisement. Putting it into practice, if you have a headline claim saying something in type 24 font, the warnings or the qualifications can't be in a footnote in size 8 amongst a giant body of text, because consumers aren't going to read that, and therefore it could be misleading. In relation to fees and costs, they must give a realistic impression of the overall level of fees and costs, and which includes any indirect fees and costs. Comparisons should only be made between products that have sufficiently similar features, or if comparing different products, the differences need to be made clear. And you just need to take a common sense approach about that. For example, a comparison where you're only really comparing one feature of a product, and that's not made clear, might not be a fair comparison of all financial products and therefore be misleading. Representations about past performance and forecasts must include warnings that, past performance does not reflect future performance and forecasts are not guaranteed to occur. Terms and phrases that you use need to be the ordinary meaning of a word and not industry jargon. Importantly, and Yvonne's already said this, but advertising content must be consistent with disclosure documents. And referring to the disclosure documents does not cure misleading advertising, or does not cure perhaps the requirement that you must include qualifications or warnings or risks. It needs to be in the content of the advertisement. Photos, diagrams, images, and examples can't be ambiguous or complicated, and they cannot contradict or detract from the prominence of any warnings, disclaimers, and qualifications. The new Red Guide specifically calls out the use of logos and branding, and warns promoters to avoid creating misleading impression about any association with that third party. I think it's quite funny, but they actually use the example of some advertisers using ASIC's logo and saying that ASIC has certified the advertisement, which ASIC would never, ever do. So don't do that. Second to last, advertisements about the nature and scope of financial advice and credit assistance needs to create a realistic expectation about what the service entails. The last point is about target audience, which I'm going to focus on a bit more, as ASIC has updated its guidance in this section, and it also now reflects the commencement of the design and distribution obligations, which I understand would apply to a lot of you guys. So if we jump to the next slide, target audience refers to the class of persons or the group of individuals to whom your advertisement is directed. ASIC has long emphasised that whilst target audience is important, advertising can be misleading if it goes to the wrong audience, and you need to consider when advertising your product or service, not only your target audience, so who you're targeting, but who may actually see the advertisement. And that's likely to be a bit broader than your target audience. And your advertisement must be simple and clearly understood by the actual audience, not just the target audience. The revised guidance now also makes a specific warning in relation to promoters advertising high-risk or complex products. And that is simply that advertisements must be simple enough to ensure the actual audience understands the risks with the products, not just the target audience. As I mentioned, RG 234 now incorporates the DDO, which is the design and distribution obligations. Hopefully you know about that, but if not, the DDO imposes positive obligations that require product issuers to determine who the target market is of a financial product before it is issued and distributed. And then also requires product issuers and distributors, so that can be promoters who aren't the product issuer, to take reasonable steps to ensure that the product is distributed consistently with that target market. So you can see how the two work together, right? And essentially Reg Guide 234 reinforces these obligations and explicitly requires advertising to be consistent with the target market. Advertising in a manner inconsistent with the target market determination risks potential misleading, deceptive contraventions, as Yvonne pointed out, as well as DDO contraventions. So it's doubling the risk. So for example, if your advertisement states or suggests that a product is appropriate for a certain number of consumers who are not in that target market, you're exposing yourself to double the risk. And another key requirement is when you're responsible for DDO obligations and you have a target market determination, when you're advertising the product and considering the target audience and the actual audience, you must be able to demonstrate that you've taken reasonable steps to ensure that the advertisement is directed to that right target market. And this will likely require consideration, as I mentioned at the outset, not only of the content of the advertisement, but how it is advertised, which we're going to get to now. So the second half of RD234, just on the next slide, please. Thank you. The second half of RD234 focuses on how and where you make your advertisement and provides specific media guidance. Generally, the key takeaway from this section is that ASIC's principles apply however you choose to advertise. And the content principles that we've just gone through apply regardless of the medium and the form of your advertisement. So basically, you're not excused. It all still applies and you've got to make it work. And ASIC has made this clear with some new key principles, which are on there on the slide, and I'll go through them. So ASIC's guidance on advertising content applies regardless of advertising mediums, format, physical limitations. So that could be short or long short form videos or big billboard advertisements that you only see for a short second when you're driving past, and the length of the advertisement. Promoters must consider the appropriateness of each particular medium based on the nature and complexity of the product or service and the ability to include balanced information in the advertisement. Probably a good example of that is I wouldn't be using a TikTok reel to advertise a really complex, high-risk financial product because you're not going to be able to provide balanced information on the risks and benefits of the product. And thirdly, the physical limitations of a particular medium are not an excuse for producing an advertisement that may mislead or may not provide balanced information. So ASIC applies this guidance, these principles, to specific advertising mediums, and which I've set out there. A lot of their guidance in relation to the advertising mediums haven't changed, especially with mass media, audio, and outdoor. The key changes and the focus of the updates to RD234 is unsurprisingly on emerging technology, which we mainly see with internet advertising. So RD234, now on the next slide, we can focus on the new changes. So it now directly refers to forms of online advertising over the last decade. This list is not exhaustive, as ASIC has made clear that the guide is technology neutral and will apply to new forms that no doubt come out soon. The new list includes paid search results, website or app-based promotional tiles, pop-up advertisements, in-app placements, push notifications, embedded advertising, and sponsored content. So not all of these advertisements are new and emerging to us. So it shows how outdated the previous guide was. But regardless, ASIC has made some specific comments on these forms of advertising. And I'll direct you to some of them. The paid search results one, so think of a Google search. ASIC recognises that promoters can lose some control over what content is in the advertisement with this type of advertising, but regardless reminds promoters that they need to take extra care with the content of claims that it does request to be included in the advertisement, and they need to consider whether the overall impression of the advertisement and whether it is balanced. So social media is a big one, and essentially ASIC's message is the same. It's that the same principles apply regardless of the varying forms of advertising on social media. So very small banner advertising where there's not much content, or in Reels where you've got a very short video and where content is fleeting. So does it sufficiently provide enough time to view risks or warnings or disclaimers? The ASIC provides specific advice in relation to those forms. But as I said, the key message is exactly the same, and there's no excuse, the same principles apply. In relation to finfluencers, which are social media influencers focusing on financial services or products, the guide and ASIC reminds licensees that you guys remain responsible for the promotional content of influencers, and you must supervise them to ensure that they comply with the law, which is pretty straightforward. Finally, we address AI. So AI in the guide is the focus on it is on content, despite the guide referring to the potential for advertising to be within AI chat tools. For now, the focus is on content. It makes clear that using AIs doesn't change your responsibilities when it comes to advertising content. And regardless of whether it's drafted by humans or generated by AI, you've got to make sure that the content is accurate and is not misleading. And if anything, AI drafted content may heighten that requirement because of the risk of hallucination or biased content. Financial advice services or products that use AI tools must make that clear in their advertisements and clearly set out the benefits, risks, and features of that tool. And finally, and I know, Tetiana, you're going to talk about this more, but whilst the Red Guide does not mention it, promoters applying these general principles that ASIC sets out need to consider the potential use of their advertisement by AI tools and take care when drafting the content to ensure that it is simple enough that it cannot be misinterpreted when people inevitably seeking advice on AI. And with that, I'm going to pass over to Tetiana.
But before you do, thanks,
Yeah.
Mikaela. Before you do, maybe just putting you on the spot here with an interesting question. So kind of put yourself in the shoes of your previous employer and try to tell people here, well, what if ASIC or someone else finds evidence that somebody was misleading people? What are the likely actions? What are we expecting as a financial service provider? What happens?
What happens? Oh, look, there's so many options for what can happen. And it really depends on the seriousness of the misleading advertisement and the potential and the impact on consumers. It could be that ASIC finds which has occurred, an obscure reference on a website, which we did once, to a mining company being carbon neutral, 100% carbon neutral, which is a kind of a silly proposition in itself. And in that, we called and you spoke to the company, and they changed the representation. For more serious misrepresentations, such as, as we saw with Choosy, ASIC will take enforcement action. They will investigate it. They'll use their compulsory notice powers, their compulsory interview powers, and they've got a very broad ability to take legal proceedings, civil penalty proceedings against companies. And also it can impact financial services licenses, and they can impose conditions on those licenses. So there's a really, really broad remit for enforcement action. And as Yvonne demonstrated on the legislation slide, the provisions that are available to ASIC are very broad again. It's not just limited to specific financial products or specific financial services. It can cover representations made in your business.
Thank you. Just bringing some practice into it. Okay, let's move into examples. We've tried to make them product neutral, and at the same time, give you a sense of what to do and what not to do. Okay, so just 5 simple guidelines. Everything that we discussed before, I've tried to distill in very, very kind of straightforward guidance. So no false or misleading statements, nowhere, and not just relying on fine print, balanced message. So what it means when you're advertising a benefit, if there's a significant risk or exclusion in the case of insurance products, you have to mention it as well. Clear and prominent, again, easy to find, not buried, not in fine print, no overstatement. This is the biggest risk, and we're going to go into this. People love overstatement or absolute statement, so just forget about it. And comparable comparisons. So what Mikaela was talking about earlier about AI, I don't know if you're experiencing the same, but as we are optimizing our own AI presence, AI is currently providing guidance or advice on financial products. So this is actually a big problem for regulators, just letting you know. They're aware of this and there are active discussions amongst regulators what to do. But AI is providing effectively product comparisons and suggestions to people. And the way how the algorithms work, at least how we are as suppliers are taught to do it, is through comparisons. The algorithms on those AI search engines, they actually love an apple-to-apple comparison. So if you're selling one product, they will encourage you to put content online, not necessarily an advertisement. It can be an article you post, it can be an interview you make, but they will encourage you to put those comparisons. And then when AI is looking for the suitable product, effectively being your broker or being your advisor, then it will, the moment there is a comparison, it will rank higher in the search algorithm. So just be very, very careful about it, because you might hear it from a lot of marketers that you should do it. If you want to do it, again, compare apples to apples, right? So kind of dangerous one, and we've been not caught into it, but we saw it. Okay, I've pulled out 3 simple cases. Some of them are very old, as you've seen. Yvonne was saying 14 years of legal precedence. I don't want to dwell on it and go into the legality of it. I just wanted to show you examples, okay? So RAA Insurance in 2018 advertised a lifetime vehicle replacement for any total loss. Okay, sounds very good. What they actually meant was that it was not any vehicle. It was a vehicle that was created or manufactured after 2014 and insured with RAA since then. So there was actually an exclusion, and they have not highlighted that exclusion. They had overstated it. Okay. Then the next one, NRMA IAL in 2021, again, promised renewal loyalty discounts, and then they were revoked. They started with a promise, and then midway through the renewal process, they scrapped those discounts and said, okay, they don't apply anymore. So the key lesson is, if you've promised it, you have to deliver on it. You can't change your mind, turn around and not do it again. And then Budget Direct, finally, it hasn't decided, well, the court hasn't decided yet what's going on, but effectively the allegation is the online discount ads did not disclose that discounts will be removed if customer updated their details. So let's say you've applied for a product, you've submitted your data, you got it, but then you went and changed your address. You went to update your address, the discount was revoked. Okay, nobody told anyone that this would happen. So key lessons again was they were just not consistent with what they've promised. Okay. All right. Now let's talk about absolute statements. So I've broken it down into advertising of products and advertising of services. They're slightly different, and slightly different rules will apply. I think Mikaela touched upon product disclosure statement and target market determination. So we kind of structured it then, but there's also, you can advertise a service, a regulated service. And again, similar rules apply, however, different practical implementation. So what you can actually say, you can state actual sum insured or limits in the policy section or reference. So let's say we are insuring your contents of your car or your jewelry or whatever up to $10,000. That's a correct statement. You will find it in the PDS. You can say that. You can name the specific events that you're insuring, like floods, collision, theft, cyclones, whatever that is. Again, have to be true. If you've got an excess, let's say on your product, you can say excess applies or no excess applies if specific conditions are met. Then if there are any specific conditions or when you need the cover to start for something to be true, you need to say that. So back to the example, when the car should have been manufactured after 2014, and then when the cover should have started at that time, that's what you need to say. You need to be explicit if you've got any conditions related to that. Then if you've got additional benefits, obviously you can mention them, but if those benefits have caps, then you should explicitly say so. Let's say, and legal cost average up to X dollars or something. And again, comparisons, it's okay to make comparisons. You just have to make them on a like-for-like basis. Again, have some factual truth behind it. What you should never say, and just really stay away from those words or expressions, because unlikely that this will ever hold true. Something like fully covered or covers everything or every product. Something like full value or new for old guaranteed and things like that. Don't forget that always can be underinsured. There can be different, clauses and conditions that can reduce final payouts or cash settlements or whatever. Then instant cover, no questions. It goes without saying. Nobody ever gets it. We all strive for it, but there's no single algorithm that would guarantee 100% of an instant cover all the time without any extra questions. And then something like no exclusions that matter. Again, we all know insurance contracts are full of exclusions, and we just need to be cautious when advertising. Now, I've also compiled, just for a few examples, product-specific traps, okay? So something like for home product, all your content's covered, as an example, will never be the case. And cash, art, collectibles, they'll all have limits. Also, for a lot of home policies, you will have unoccupancy exclusions. And if you even go through AFCA cases on, what do people complain about and where do they dispute decisions, a lot of it happens in those exclusions that are not necessarily visible, or even people buying the policy don't necessarily know about them. Then motor, something like you can't say any driver, any damage. You've got a whole bunch of restrictions on unlisted drivers, young drivers, wear and tear, mechanical failures, and so on and so forth. Then something like a biz pack should never say covers your entire business, because obviously depending on the sections selected and covers selected, limits selected, it will always exclude something or not cover the whole thing. Here, fleet, every vehicle automatically covered. Again, depends on declarations, notifications, conditions, select like many conditions that can apply to fleet. And final example, liability covers any claim against you. Again, not true. Many claims, liability claim that won't be covered. A lot of it contractual, professional advice, pollution, employment claims, and so on. So just examples of what's okay to say and what's not okay to say. Now, when coming to services, okay, so when you advertise your services, and I kind of particularly thought about brokers when putting this together, unlike products where you always have to anchor whatever you are saying in a product disclosure or a product document, in services is different. What you need to anchor it to is context. You can take stuff out of context and present it as the universal truth that will apply to every customer. Okay, so that's slightly different. So, for example, a broker or like a financial advisor could never use words complete protection or fully covered. Okay, if it's the case for some of their clients, and if they can back it up with this claim was fully paid or this liability or something was fully covered, that's okay. But it cannot overstate the reality. If it was one client out of 10 or out of 100, you cannot take it out of context and say, oh, it's always going to be the case. Here, again, we compare the whole market. We've seen it with the likes of Choosy, but it specifically applies to brokers. And brokers usually use FSGs to actually specify what portion of the market do they actually cover. And it's a bit tricky to say what are you covering or what are you not covering, but effectively to say we compare the whole market, unless you really do that, you can say that, but probably not. Then something like savings. So our clients save up to 50% on the premium or on something. Again, it's all right if you can prove that works for the majority of your clients. If that doesn't work for the majority and work for 1, 2, or 3, you can't use things like that. You can't say, oh, we guarantee lower rates than some other brokerage or something. Here, from X dollars per month, like a teaser pricing, again, saying same principle. If it applies to majority of the people, yes. However, the likelihood of that is almost zero, because people have different sums insured, they insure different things, and it's very hard to generalize what exactly that pricing applies to. And asterisk abuse, who hasn't done it? Moving very, very important statements into small, tiny fonts hidden somewhere at the bottom. No. Or linking it to different pages. No. Here, independent advice. And again, I've seen it so many times. The moment you're receiving a commission, that's it. You're not independent. You cannot use the word independent. Only if you have a fee for service, and you're properly not representing anything, don't have any binder agreements, anything like that, not owned by anyone, only then can you use the word independent. But at the moment there's some conflict, and we've gone about it quite a bit during our conflict of interest debates. The word independent is very, very tricky. So unless you're truly, truly independent, including no commission, then you can use it. Then a typical claim stories as testimonials, paid within 48 hours or 400,000 settled in a week. Again, fine if it's true. However, if it's not true for enough people, then you can't prominently advertise it. No like comparisons, we already discussed that. Here, we make sure you get paid. Again, you cannot guarantee that unless, you're properly, you are the insurer. And even if you are the insurer, you probably can't always guarantee that. So that should not be part of the service. You can advocate on behalf of the customer and you can kind of fight their battles and help them, but you cannot guarantee anything that, how the decision is gonna go at the end. And finally, to Mikaela's point about where you advertise is wrong audience reach. So primarily complex and potentially wholesale only products that, are being pushed through Facebook or other kind of mass media channels that would potentially attract the attention of retail customers. All right, so these are the kind of the two different practicalities for it. To finish up, just put together a little checklist. So obviously we asked you at the beginning if you are running a process currently, if somebody is looking at what you're putting out there. And I know the guide is called advertising, but in the end, I hope one message that you're going to get from this webinar is it's not just about advertising. It's everything that you put out. It's your social media presence. It's the articles that you publish on your website, the article that you might publish on LinkedIn or other social media. It's the comments that you make. It's press interviews that you give. It's any kind of printed or not printed communication that goes out of the firm. Okay. And it's very, very dangerous that one person says one thing and the other one says the other thing, and none of them have actually checked what our guidelines are or what our product says. So what we suggest as a kind of how you comply with this, the law plus the ASIC guide, that if you are a product issuer, if you've got PDSs or products, you have almost a little cheat sheet per product to say, what can you say, what can you not say? So you think about it proactively and you go double check it. So every time you want to run something or run some campaign, you can go and almost select from the menu. Then absolutely name one person as a reviewer. And that person should not be the one who's putting the advertising. So you always need to have a 4-eye principle. Okay, so just think about who that person might be. Always have a second pair of eyes looking at something before it goes out, even, as I said, LinkedIn posts and stuff. Then for every little piece of content, again, we try to make it super, super practical to say, okay, back to Yvonne's message, if you remember, if a customer only looked at it once of what you've produced, what impression would they get? What would be the message that they would receive? Here, if you are stating something specific to the product, or can you actually back it up? And do you provide a reference to that document, for example, a PDS? So if you said something, you named the number, or you set a limit up to $10,000 or something, can you actually refer to where the customer can find it as a document and a proof? Here, is the qualification as visible as the claim, meaning do not hide that proof somewhere very, very deep. Try to say and refer to this PDS or refer to our website or refer to this document or something so that people can kind of connect the dots quickly and not spend time looking for it. Yeah, is the right audience for the right channel? We discussed it already, right? Do not try to advertise very complex wholesale potential products on like broad audience places where broad audience goes. Then compliance sign off, again, it's a very recommended step. And the reason I asked you how you're doing it, because obviously there are ways to automate it, right? But just forget about the automation. But what needs to happen is someone needs to review and sign the final version, not a draft, literally before it goes out. it's a good practice to keep a record of those. Okay, especially for larger firms, the reason they get penalized quite a bit compared to smaller firms is because they will have different departments and different people looking at those, and there can be inconsistencies even within one firm for two different divisions or products or departments. So it's actually good to keep a track record of who approved what and what actually went into the public. Again, don't overcomplicate the approval. You can do it in a simple email or list or somewhere really, really simple. Just say who did it, when, and what. You say no self sign off. So 4I principle. So do not approve your own stuff before it goes out. And finally, just a little hygiene on the quarterly basis. Just look at everything. Look at all of your channels and have a look if you find something that's standing out or not quite right. Kill or fix anything stale. That's particularly dangerous when things are changing, right? You've changed pricing, you've changed the wording, you've added a new version of something or a new TMD or something, and you're still referring to it in your online presence or advertising that's already somewhere out there. So if that's the case, you just take it down. Okay, so that's not applicable anymore. Or you update the advertising and the guide underlying. And always look through your complaints. They're really good indication for when the clients actually misunderstand you. And a lot of it can be a marketing problem. And we actually work with a lot of clients who say, oh, but that's not a complaint. They thought they were buying this, but they were actually buying this. And we're always saying, well, it's a very valuable source of information and it is a complaint. So, all right, I'll pause here. Unfortunately, I can't see the chat, but about a few minutes until the full hour. Are there any questions? No, just looking at it. Can't see any questions. People usually tell me I'm switching off and finishing off too quickly. I'll give you a minute to put your questions through. I cannot see anything in Q&A and I cannot see anything in the chat. If there are no more questions, just saying, Yvonne, Mikaela, can you just check the Q&A? Okay, nothing. Sorry.
I think there's just a question now from Hayden. Why then are there so many non-compliant websites and social media ads?
That's true. That is unfortunately true. I would direct the question to Mikaela. The closest to the enforcement.
Yeah, I don't think I mean, I obviously don't speak for ASIC, but I don't think they disagree. I think there's a lot of non-compliant websites because people, as we've seen with your poll, Tetiana, people either don't know enough about what's required and what is misleading and deceptive, don't have sufficiently robust compliance approach to advertisements, or as sometimes happens with these big organizations, things go through so many hands that the people who actually understand the product to prepare the advertisement, the accuracy is lost by the time it goes through the media team and everything like that and actually gets published. So I think there are a number of issues that we can see with advertising.
I think what you see is that there's a lot more focus and attention paid to regulated disclosure documents, so your PDSs, your TMDs, other documents that have really prescriptive requirements for the content that needs to go into those documents that are designed to help retail customers understand the product they're buying. But then they're not outside of that space where it's a regulated disclosure document. There's the whole minefield of everything else that sits together with those documents and overall creates a full patchwork of information that's going to customers, whether they're retail customers, wholesale customers, whoever they are. And that part is the part that we don't always see marries up with other parts of the business where you've got policy wordings and as well as those PDSs and other documents. And it's almost like you've got all these representations and promises out there within a business, but different teams looking after different parts of that and not always having that alignment internally. So that's why sometimes you see the websites or the social media going through marketing parts of the organisation and being signed off from that perspective, and then more like legal risk and compliance focus on those really regulated documents only, but not necessarily always being extended to all the different other channels that you could be communicating with the public or audiences at large.
Yeah.
The question here, would ASIC allow non-compliant ads to have something? This is for promotion only, in-app results may vary. Question is, can it be a way out if you say something like this? No.
Maybe
with the most recent guidance, that's less likely.
I think it answers itself, though. This is promotional only. Promoting what? If it's promoting something misleading, then it is misleading. Yes, very much a big cop-out.
Would you be able to share the slides? So what we usually do, I don't know if you're following us. So we usually publish a transcript of an article. Sometimes we publish a full recording, and we also publish the slides on our website. So once it will take us a little bit of time, but usually it's within a week or 2 weeks. But that's fully online, and you can go download them. But if you want, just message us. We'll send you the actual slides. All right. Thank you, everyone. We're 3 minutes over the hour. Thanks, Yvonne. Thanks, Mikaela. We'll see you at the next one.
Thanks, everyone. Have a good rest of the afternoon.